Good afternoon and happy Halloween. Thanks for joining today's webinar, which is Medicaid TBI services in New Jersey, access, eligibility, and legal rights. Thank you for joining, and my name is Rachel Ishak, and I am a community outreach specialist here at the Brain Injury Alliance of New Jersey. The Alliance is a nonprofit organization with a mission to provide education, awareness, prevention strategies, advocacy, and support for those who have been impacted by brain injury. I would like to announce that we have a tab on our website where you can view and register for all of our upcoming webinars for the next few months. Our next webinar will be on November 16th, and it will cover yoga, the Love Your Brain program. You can register for all of our upcoming webinars using the link I've placed in the chat. Just a couple of housekeeping notes before we begin the presentation. The attendees' microphones have been muted, so if you have any questions during today's webinar, please type them in the Q&A box. We will get to as many questions as we can at the end of the presentation. The webinar is being recorded and it will be available for viewing on the BIANJ website afterwards. At the end of the webinar, a link for a post-webinar survey will be placed in the chat. We value your feedback, so you're encouraged to complete the survey. Once you complete the survey, you will receive a certificate of attendance automatically through email. You have to complete the survey in order to get that certificate of attendance. And our presenters for today's webinar are Michael Brower and Melissa Zeidler. Michael Brower serves as the legal director at Disability Rights New Jersey, which is a nonprofit agency designated as the protection and advocacy system for people with disabilities in the state of New Jersey. He has worked as an attorney there since 2016 and has represented clients and worked on systemic issues impacting individuals with IDD, brain injuries, physical disabilities, and mental health conditions. Before joining Disability Rights New Jersey, Michael represented people struggling with medical and consumer debt in New Jersey and Pennsylvania. Michael received an undergraduate degree in history from the College of New Jersey in 2009 and his law degree from Rutgers Law School in Camden in 2012. Melissa Zeidler is the managing attorney of the Community Inclusion Team at Disability Rights New Jersey. She started her legal career as a staff attorney at Nassau-Suffolk Law Service in Long Island, New York, representing clients with low incomes and cancer diagnoses. She then moved to the Urban Justice Center's Mental Health Project in New York City, representing clients with low incomes in seeking federal disability benefits from the social law. Melissa is licensed to practice law in New York and New Jersey and is admitted in the Eastern and Southern districts of New York. So with that, I am pleased to welcome Michael and Melissa. Take it away.
Great. Thank you, Rachel, and thanks to the Brain Injury Alliance for having us here today. I'm going to share my screen and then we're going to get started with the presentation. Okay, great. Looks like the screen share is on. Question, am I on the full screen? Am I on my presenter notes? I think I'm on presenter notes. Bear with me just 1 second, get the right screen going. There we go. We have full screen slides now. Great, thanks. So just a couple of quick introductions to the organization. Disability Rights New Jersey, as Rachel mentioned, is the protection and advocacy system for people with disabilities here in New Jersey. One more level of detail, we provide both no-cost legal assistance to people with disabilities on a variety of issues that we lay out in our annual goals and objectives documents on our website, which I would invite everybody to review. We have links at the end of the presentation so you can see the different issues that we address. We work a little bit like a nonprofit law firm in that regard. We also conduct investigations independent of the state or of any client of abuse and neglect against people with disabilities. And we serve people with all different types of disabilities, as we talked about a little bit in our individual intros. One other disclaimer before we get into the meat of our presentation. We're talking about law and we're talking about legal concepts and rights in this presentation. Both Melissa and I are licensed attorneys here, but we are not providing any legal advice in this presentation or in the Q&A. So if you have a specific problem that affects you and maybe relates to the topic of the presentation, I would really encourage you not to seek legal advice in the Q&A, but rather to consult privately, whether that's our organization or another attorney. We don't want to form any attorney-client privileges here in a public forum. So I just want to get that laid out off the bat. With that being said, we're going to start into the slides here. That's us. I have slightly more hair in that picture. And other than saying I'm the legal director here and I supervise the legal work that our agency does, I don't want to waste any more time talking about kind of me or my background here. But I do want to turn over the microphone to Melissa so she can introduce herself and get on this slide.
Hi, everyone. Nice to be here. I also don't want to take too much time with that.
Wonderful. And just once more, that disclaimer is on the screen. No legal advice happening in this presentation, even though we are both lawyers. All right, Melissa, lay out our roadmap for today.
This is mine. I'm sorry. Today we'll be talking about Medicaid context, the TBI specific services in MLTSS, eligibility for MLTSS, which is the managed long-term services and supports through the Medicaid program, and appeals through managed care.
And I'm just going to say that this is a lot to cover in the hour that we have. So we're going to try to give a good flavor and the information that you might need either as a beneficiary, as an advocate, as a family member, for somebody with a traumatic brain injury, so that you can identify issues. Anything that we talk about, you could have an entire law school course on. And so we're just going to try to give a little bit of that flavor as we go through today. I'm going to start us off with the Medicaid context. The presentation, as the title says, is focused on Medicaid services for people with traumatic brain injuries. And to set that stage, I just want to give a little bit of context. How does Medicaid work? Because really, Medicaid is one of the most complex public health programs in the world. It's governed by an intricate set of federal rules, state laws, and I think judges have gone on the record and say it's almost like one of the rings of hell trying to untangle all of the different interplays in Medicaid. But for our purposes, we can really simplify that. We can boil everything down to the core principles. Medicaid is a federal spending program. It started in 1965, and really what we're talking about is a state-based healthcare system that can receive federal subsidies. This is a state and federal partnership. The idea is to provide medical services for older adults, people with disabilities, and people with very limited financial means to pay for their own care with help from the federal government, but administered by the states. A state is not required to have a Medicaid program, but if a state decides to have one, it must follow all of the federal rules and the very strict requirements that go with receiving that federal subsidy. In the real world, all 50 states have a Medicaid program, including New Jersey. And the real perk, the reason to do this for any given state is that for every dollar that a state spends providing medical care through a Medicaid program, it gets about 50 cents on average back from the federal government, essentially doubling a state's budget to provide care for the citizens of the state. And actually, let me scratch it, not the citizens, the residents of a state. There's a lot of federal requirements that come with this partnership. States are required to provide certain benefits through its Medicaid program. At a minimum level, states need to cover things like doctor's visits, prescriptions, hospital stays, and long-term care in large institutions like nursing homes for the people who need them. So these are kind of the minimum levels of participation. Once a state signs up to have a Medicaid program, they need to provide at least those things. States can also add optional services to their Medicaid programs, things like dental coverage, private duty nursing, where an individual gets assigned their own nurse to provide care in their home, adult medical daycare, or personal care assistance, where the Medicaid program can pay for an assistant to help somebody get through the activities of daily living, like getting dressed or bathed or getting in and out of bed, making meals, taking care of the house, and things like that. Generally speaking, one of the federal requirements is that a state can't use its Medicaid dollar to pay for non-medical services. living expenses, for example, are not supposed to be covered by Medicaid. Rent, food, clothes, non-medical transportation. Those kinds of services aren't allowed to be part of the Medicaid program unless there's special permission or a waiver from the federal government. We're going to talk a lot more about waivers later. In New Jersey, this state and federal partnership ends up under the brand name New Jersey Family Care. If you've worked in the Medicaid space before, you've seen that logo that's up on the screen. Everything Medicaid comes under that brand name. There's also some non-Medicaid programs like the Children's Health Insurance Program that gets labeled New Jersey Family Care. Children's Health Insurance Program is well outside of the scope of our presentation. But just know that if you see that, you need to make sure you're talking about Medicaid before you get into the application of the rules we're going to talk about today. Everything in the state of New Jersey that is Medicaid is run by the Division of Medical Assistance and Health Services inside the state's Department of Human Services. They administer all of the Medicaid programs. Some of the eligibility that we'll talk about, the Division of Medical Assistance will enlist county welfare agencies or boards of social services to help them make eligibility determinations for people applying for Medicaid. The division and those counties, they control eligibility and enrollment. They determine who gets Medicaid services here in New Jersey. Once somebody has been enrolled, beneficiaries for Medicaid receive nearly all of their benefits through one of the 5 managed care organizations, or MCOs. So if you're a Medicaid beneficiary yourself, or if you know somebody, you've probably seen somebody gets a card, both in the state that says you're eligible for Medicaid, but you also get a card from your MCO. That would be United Healthcare, Horizon New Jersey Health, Aetna, Amerigroup, or WellCare. They are the 5 MCOs that operate in New Jersey, and they work just like a health insurance plan. They have a network of providers, doctors and hospitals, pharmacies, what have you. The MCO manages the payment for all the services, and they also do approval and denial work, making sure that only covered services get paid. We're going to talk a lot more about that later as well, but I just wanted to give you this background on how Medicaid comes into New Jersey and where the money comes from in the first place. Once you're enrolled in Medicaid, assuming you're somebody who is eligible, you get access to state plan services. Everybody who's in Medicaid has access to the state plan services, and those are very, very many. There's a lot of service that state plans cover, but the essentials are what's in the bubble on the left-hand side of the screen. It's easy to think of these probably as the plain vanilla health insurance parts of Medicaid. And these services are just part of the state plan. They're more common and they're more health related. So you might say, for example, doctors, hospitals, dental coverage, prescription coverage, and even adult medical daycare, all part of the state plan. Anybody who's enrolled in Medicaid has access to those kinds of services. And again, all of those services are actually accessed and administered by somebody's managed care organization. New Jersey does not include private duty nursing, even though it could. It does not include it in its state plan, so not everybody who has Medicaid gets access to private duty nursing. And remember just a slide ago when I said that states need special permission or a waiver from the federal government to use their Medicaid money for non-medical services? Well, we have in New Jersey a comprehensive Medicaid waiver, lots of permission from the federal government to provide a broad array of special services. They're usually meant to make it easier for people with disabilities to live in their own home or in a community-based setting. There are special eligibility requirements to get waiver services. Not everybody who gets Medicaid gets those. So you need to actually have eligibility both for Medicaid and the specific waiver program for the services you might want. We're going to talk more about MLTSS. I don't want to short circuit some of those future slides, but know that that is one of the waiver programs. And to give you an example, a waiver can open up access to services like private duty nursing, which not everybody in New Jersey has access to, home or vehicle modifications, things like adding a ramp or widening doorways, the community TBI services that we're going to talk about in a lot more specificity, and even totally non-medical services like chores. So here, think about things like the services somebody who might otherwise live in a nursing home, the services they might need to stay living in their own home, home delivered meals, gutter cleaning, deep cleaning of the home, right? Moving the stove and vacuuming underneath once in a while, shoveling snow in bad weather, right? Those are the kind of services that the state can provide through its waiver programs to make it easier for people to keep living in their own homes rather than living in a large institution like a nursing home. That being said, MLTSS does cover long or short-term stays in nursing homes for people who need them. All of these services, just like the state plan services, also come through the managed care organization. Just for a little historical note, there used to be a small standalone TBI waiver program that was a waiver service program just for people with TBIs. It was at a very small cap, I believe it was about 400 people. In 2014, the state combined that waiver with MLTSS, and we're going to go into, like I said, more detail on that next, so I'm not going to shortcut that. For the next slide, I'm going to pass it to Melissa to take us off.
Thank you, Michael. So what is MLTSS? It is Managed Long-Term Services and Supports through New Jersey Medicaid's NJ Family Care Managed Care Program, like Michael said. And as he mentioned about the waivers, they are designed to keep people in the community. So this specifically is designed to expand home and community-based services, promote community inclusion, ensure quality and efficiency of the services. So it's really meant to keep people at home or otherwise in their community and avoid unnecessary institutionalization. Next slide. Now, MLTSS provides a range of services, and like Michael said, the TBI services are within MLTSS. There's a link here to the service dictionary. So once someone is eligible for services or for MLTSS coverage, period, they might be eligible for certain specific services that MLTSS provides. There are TBI specific services in here, like we mentioned, but once you're on MLTSS, you might be eligible for any service that is in there, not specific to TBI or specific to TBI, so long as it is medically necessary. So there's two issues within that we'll be talking about later: eligibility for MLTSS as a whole, and then eligibility for specific services. MLTSS beneficiaries can also access all of those state plan services that Michael talked about before. Next slide. So these are the TBI specific services within the MLTSS program. There's behavioral management, community residential resources, cognitive rehabilitation therapy, occupational therapy, physical therapy, speech, language, and hearing therapy, respite, and structured day program. These are the services that are TBI specific. And again, though, you don't have to necessarily get these services. Any services in the MLTSS dictionary might be available to you. Next. I want to go through these a bit quickly. This just has more information about these specific services. So behavioral management is designed to service recipients who display severe maladaptive or aggressive behavior. It can be provided in and out of the home. It's supposed to be time limited, and it can be for a person or for caregivers. Next. The community residential resources goes more into those other services that Michael was talking about. There's personal care, companion services, chore services, transportation. So things that are a bit broader than just the medical coverage like he was mentioning. Next slide. Cognitive rehabilitation therapy is therapeutic intervention for maintenance and prevention of deterioration, which include retraining, use of compensatory strategies, and cognitive orthotics and prosthesis. Next slide. These three all had the same definition. So this is the point of these specific therapies, is to develop or improve skills, prevent loss of previously attained progress. And all three of these are meant to do the same thing in their specific categories. Next. Respite is for participants who are unable to care for themselves, and it's supposed to be on a short-term basis due to the absence or need of relief for a caregiver. Next. And then there's a structured day program, which provides supervised activities for the development and maintenance of independent and community living skills. This is provided outside the home. It can be group or individual, and it's preparing for community reintegration. So it can work on things like attention, task completion, problem solving. It also has other things like nutritional supervision, health monitoring, and recreation. Next. So getting a little bit more specifically into MLTSS eligibility. there's three things we're going to talk about, and these are the three of them. There's clinical eligibility, which means you have to meet certain medical criteria. MLTSS defines that as an institutional level of care or a nursing facility level of care. That is in quotation marks because that is a specific term in the MLTSS world, and it means something specific. There's also financial eligibility, which is mostly based on income and resources, and income is what you receive in a particular month, and resources are what carries over from month to month. And finally, there's a third consideration, which I am calling financial considerations because they might affect eligibility, but it's not an eligibility criteria per se. And that is also about finances, which we'll get to in a minute. Next slide. So what does institutional level of care or nursing facility level of care actually mean? That means something different depending on your age. So for people who are 21 and over, it can mean limited assistance with 3 or more ADLs. It can mean problems with short-term memory and minimally impaired with more with decision-making and requires supervision with 3+ ADLs. Minimally impaired with decision-making and making themselves understood requires supervision in 3 or more ADLs. So the common factor in these is the 3 ADLs. An ADL means activities of daily living. So this institutional level of care or this nursing facility level of care might not mean what people think it means outside of this context. So for MLTSS, this is what institutional level of care actually means, mostly the assistance with 3 or more activities of daily living. So financial income, the way they consider income, you're allowed to have income up to 300% of the federal benefit rate. This is also known as the SSI rate. So in 2023, in this year, the individual SSI rate is $914 a month. $914 times 300% is $2,742. So this is where the income is capped to remain eligible for this program. That changes every year. It goes up a little bit every year. This is where it is now. And this also only considers certain types of income. So it can count wages, unearned income like SSD, pensions, trust disbursements. However, it doesn't include all income. And this is a bit outside the scope, but income is defined in the regulations and it counts only some income. Another thing people should be aware of is there is such a thing as a qualified income trust. So if someone has income over the limit, this trust might be an option for them to put that excess money into and remain eligible for these programs. Next. Resources has a limit of $2,000 for an individual, and resources are the things that carry over month to month. So this can include money in a bank account, it can include other goods, stocks, bonds, things like that. But again, not everything is actually counted. So your primary residence, if that's the only house you own, that won't count. If you own multiple houses, then the value of the other houses might count. One car doesn't count either. Next. So now we're into the financial consideration stage. And this is a bit of a complicated one, but there is a transfer of asset rule. So earlier I just said, right, the asset limit is $2,000. If you have more resources than that, you won't be eligible for MLTSS financially. The problem with that is when you become eligible for institutional level of care, which again was what MLTSS is looking at, that institutional level of care. Medicaid will do a review of any assets that you transferred within the 5-year period leading up to that. And there is a presumption that anything transferred within that time period was for the purpose of becoming eligible for the program. Now, that presumption can be rebutted, but in practice, it is very, very difficult to do so. And not everything counts. If you're transferring things for fair market value, that might not be counted. But mostly, they will be looking to see if anything was transferred, and they will assume or presume that it was for the reason to become eligible for MLTSS services. So if that's what they're thinking, the penalty might be that there is a period of ineligibility for the institutional level services. So this means that the MLTSS services might be affected, everything we talked about just a few moments ago, but not other Medicaid Plan A services. So if you recall that slide that Michael had up, that had the Plan A, it had the MLTSS, it had some that were overlapping. if someone is in this situation where they're in a transfer of assets, look back, and there is a presumption that assets were transferred for the purpose of being eligible, the MLTSS services might be affected because it is the MLTSS services that require that institutional level of care. The Medicaid Plan A system does not require that, so that it has a different rule. This is a really complicated concept, so if there's questions about it, we can get to them at the end. Next slide. Another consideration is that at the time of the application or redetermination in the waiver, like Michael mentioned, it says that if the income is below 100% of the federal poverty limit, which this year is $1,215 a month, New Jersey will not review assets. Next slide. And final thing is estate recovery. This is not specific to MLTSS. This can affect other Medicaid beneficiaries. And essentially is that Medicaid may try to recover funds from the estates of deceased beneficiaries for some services Medicaid pay for. It could be postponed until there's no surviving spouse, no surviving children under 21, no surviving children who are blind or permanently and totally disabled. This can come into play in a lot of different ways, depending on trust, depending on age. So we would suggest consulting with a Medicaid planner or an attorney, like Michael mentioned, if you have specific questions to your situation. Next slide. Now I'll switch it back to Michael to talk about eligibility and appeals.
Wonderful. Thank you, Melissa. And so just to kind of recap, we've now talked about the Medicaid context, how MLTSS as a waiver program works in the context of New Jersey. We've talked a lot about the services, and Melissa reviewed the TBI specific services that are coverable under the MLTSS waiver for people who are eligible. And we've talked about some of the financial criteria and the clinical criteria and some of the financial considerations to worry about when you're looking at MLTSS eligibility. I want to just say again, these are all very complicated topics, and we're trying to get them as an accessible and easy way for people to understand quickly as we can. But oftentimes where the rubber hits the road is where somebody applies for Medicaid. They think, they look at the eligibility criteria that Melissa just reviewed, and they say, oh, that's a service. I need those services. It looks like I should be eligible. And you go and you apply. You either go to the state's website at NJ Family Care, or you go to your county board of social services where you can do an application for Medicaid, and you get denied. This is often where the rubber hits the road. This is where people start to need to really understand what are their rights, what can they do, and what can't they do. And so what I put up on the screen is actually a picture of a MLTSS eligibility termination. And federal law, from the Constitution of the United States all the way down through the statutes and the regulations, all require that if somebody applies for Medicaid and is denied, or if somebody's already getting Medicaid or MLTSS, and the state decides to terminate that eligibility because they think something has changed, in either of those circumstances, the state is required to issue a written notice that contains a clear explanation of what the decision is, why the decision was made or the reasoning, and an explanation of that person's appeal rights, whether they're an applicant or a beneficiary, with instructions on how that person can request an appeal. So for a termination of existing eligibility, meaning somebody who had MLTSS, but something has changed, either their clinical condition has changed or their financial condition has changed, the notice needs to come before the termination actually goes into effect, and it has to come with the option to continue benefits during the appeal process. For eligibility, meaning whether or not you get MLTSS, there's only one kind of appeal, and that's called a Medicaid fair hearing. A Medicaid fair hearing is where both the Medicaid agency and the applicant or the beneficiary can get in front of an administrative law judge. They can submit evidence, question their witnesses, and provide testimony under oath about the underlying facts that would have affected eligibility, whether that be clinical, financial, or both. So that might be testimony about somebody's ability to care for themselves. It might be testimony about assets in the bank, maybe testimony about income or changes in income. The applicant has the right to access their entire case file so they can see everything the Medicaid agency has on them before the hearing. including things like clinical assessments, past clinical assessments, or financial records that the agency pulled, or even things like computer records that the Medicaid agency has about an applicant, which oftentimes are very important to decide how that appeal should go or not. So it's important to know that applicants have the right to see those records before the hearing. One important thing I just mentioned, but it's worth reiterating, is that if somebody was already enrolled in Medicaid or an MLTSS, and they get a termination notice from the state or from their county, they can also get continuation of benefits during the appeal process. That means that you keep your Medicaid services. You don't lose them. You keep them during the appeal until a final decision is reached. Normally, there would be a 20-day deadline to request a fair hearing and get your benefits continued. But because we're in this unwinding period, we just came out of the COVID-19 public health emergency. Part of the unwinding process is an extension. That deadline has been extended to 60 days from the date of the termination notice for somebody to request an appeal or to appeal denial. The issues about eligibility, if you did not get the sense from Melissa, I want to again reiterate that here, it can be complex. Even though a fair hearing is a relatively relaxed process, it's still before an administrative law judge, and it's still a formal hearing at the end of the day. It can be difficult to present your case on eligibility, whether you disagree with the denial or you disagree with the termination. It's always a good idea, if you can, to have the help of an attorney with a fair hearing. There are some circumstances where Disability Rights New Jersey can, but there are also many cases where we may not be able to provide an attorney to help you. In those cases, we try to provide good referrals to help you find an agency that can provide a low cost or no cost attorney for representation about Medicaid eligibility. I just want to highlight one thing. There's the notice up on the screen. It's worth pointing out that this date is from before the pandemic. It's from February 11th, 2020. They look pretty much the same as they do now. But you'll see that the first page of the notice is an explanation that this person is not clinically eligible for the nursing facility level of care. Melissa provided that definition so that hopefully you have a little bit better sense of what that might mean. And the second page is the instruction that if you want to appeal, you can request a fair hearing. It has some relatively straightforward instructions along with a mailing address and a fax number of where you could submit a hearing request. I would just cap this off by saying, if you are finding yourself in a position to request a hearing on an appeal, A, keep a copy of any paperwork you submit, and B, make sure that you send it in a way that you can get some form of confirmation, whether that's the fax confirmation, or if you send it by mail, certified mail with a return receipt, so that you know the document was sent and when it was sent, and you have some kind of a record in case there's ever a dispute about whether or when you requested an appeal. Just to give you a sense of how this process works, once you request an appeal, relatively straight pathway here. The document that's called the fair hearing request gets transmitted to the Office of Administrative Law. That's where the hearing takes place. The OAL issues an initial decision that gets submitted back to the Division of Medical Assistance and the Director of Medicaid, and they will make a final determination on what eligibility should be like, whether the eligibility should have been continued, should have been stopped, or should have been approved if this is an application from the first sense. This is just a very basic timeline. You should know in practice, this might take several months to work your way through all these steps. Some of those deadlines can be extended, and that means it might take a long time. All the more reason to get continuation of benefits before going through the appeal process to make sure you don't lose access to basic health coverage or the services or supports you might need to keep living in your setting. And again, I just want to highlight that right now, at a temporary basis, that deadline to request the fair hearing is 60 days, not 20 days. Let's assume, however, that you don't have an eligibility problem. You're on MLTSS, you apply and you get on. That's just how it's supposed to work. Or you don't have any kind of a termination. But let's say you're having a dispute about a particular service. Up on the screen is a managed care adverse benefit determination. That is a very specific term of art. What it means is that you asked for a service and the MCO reviewed and said, nope, that's not medically necessary. Or you've been getting a service and your managed care org says, that's either no longer necessary or we're going to reduce it, meaning they're either terminating it or reducing the amount of that service you get. I know this is a little bit blurry on the screen. What I really want you to look at is just the shape and what this document looks like. This has to be sent to you by mail, has to be a paper copy that gets to you, the beneficiary. It will start with a date. It will come with the same constitutionally required notice. What is the action? When is it going to take place? And what are your appeal rights? This is an opportunity, if you get one of these, to review the reason that the managed care organization took a particular adverse action to you. You have the right to appeal. If you have an existing service that is being reduced or terminated, there's a very tight 10-day deadline. So I want to highlight that is 10 days from the date on the notice to request an appeal with continuation of benefits. That means that if you request an appeal within those 10 days, you keep your benefit during the appeal process. If we're talking about something like physical therapy, personal care assistance, or even coverage for a community residential service, which might be a group home, you want to keep coverage during the appeal process because otherwise you lose it and you might not be able to even go through the appeal without the supports that you need day to day. If you miss that tight 10-day deadline, you might still get the chance to request an appeal, but you would not have the guarantee of continuation of benefits during the appeal process. The 10 days is measured from the date on the notice. That's why I put that first big red arrow up there. This notice is dated May 9th, 2018. It's an older notice, but the rule's the same. You'd count 10 days from that date, and that is your deadline to file the request for appeal. I want to go through what that appeal process looks like so you know what to expect, and know that there are 2 steps to appeal when you're talking about a service rather than MLTSS eligibility overall. So the first step is that the MCO must provide a written notice whenever they decide to deny, reduce, or terminate a service under Medicaid or MLTSS. You have a chance and you must go through an internal appeal process first. This is where you ask the managed care organization to take a second look at its own decision. It's an internal review. The 10-day deadline applies here. From the notice that you get about the original decision, you can request an internal appeal within 10 days if you have an ongoing service to get continuation of benefits. If you're applying, you have a longer deadline, but know that if you have an ongoing service, I just want to keep emphasizing 10 days from the date of a notice. If you miss that 10 days, you might not keep your services. If the managed care organization looks at your internal appeal request and decides to uphold its decision, meaning it keeps their decision, whether they decided to terminate, reduce, or deny your application for a new service, if they decide to keep it, you have another opportunity to appeal. This time, you would have the chance to go to a fair hearing. A fair hearing, just like for eligibility, goes in front of an administrative law judge and is an opportunity to explain why the decision was wrong. Like the first step, the internal appeal, you can keep your services if you have an ongoing service during the fair hearing process, but only if you make the fair hearing request within 10 days of the date on the second notice. Again, I want to emphasize here that this means you need to make 2 different appeals on time. If you're appealing a managed care organization termination or reduction, you have to make 2 different timely appeals to keep your services. First is 10 days from the initial notice. Second, if you lose at the internal appeal, you have 10 days from the second notice to request a fair hearing and keep your services. If you miss either of those, you have a very high likelihood of not having access to your services, even if you ultimately still get a chance to appeal the decision. Just like the hearing for eligibility, you have an opportunity to present witnesses, to question witnesses from the managed care organization, to present your own documents, do whatever you need to prove that a service denial, reduction, or termination was wrong. One practical tip right now, these are all happening by telephone, which is a very difficult way to present any kind of medical information or evidence. I would advocate for anyone who's handling a hearing to ask for it to be held at least by Zoom, if not in person, at one of the court locations. After the hearing gets processed, or after the hearing is complete, rather, the administrative law judge issues an initial opinion, which goes to the medical director, just like eligibility was. and the Medicaid director at the Division of Medical Assistance and Health Services makes a final decision, and they can either adopt the judge's decision, reject it, or modify some parts. And the Medicaid director's decision is what becomes final. This process can take several months, longer even than eligibility can, which is one of the reasons why I keep highlighting how important it is if you want to file an appeal to do so quickly if you have an ongoing service. Otherwise, you might go this entire length of time, right? We're talking 60 days, 30 days, maybe another 120 days. You've got a long time here where you might go without services. So it's important to hit those 10-day deadlines if you have a service that's being reduced or terminated that you want to keep. One thing I want to mention here, it is just as important as the fair hearing, is that for most MLTSS services, you also have the right, in addition to going to a fair hearing where you go before an administrative law judge, to also seek an external review. An external review is its own process where an out-of-state doctor who is not associated with the managed care organization and not associated with you in any way, someone who is totally independent, has an opportunity to review medical records. It is only a records review. There's no hearing involved. And they can review the records and make an independent determination on whether or not the service should have been denied, reduced, or terminated. This can happen on a sidetrack along with a fair hearing. It doesn't extend any of those deadlines, though. So you should know that if you decide to go through the independent review or the external review, the fair hearing deadline clocks will all still keep ticking. Some people make a strategic decision that they only want to do one or the other. You should just know that they are both available to you. Instructions for the external appeal will be included right alongside the instructions for the fair hearing after you go through the internal review. Both of those steps happen only after the MCO commits its own internal review to the record. All right, I'm going to talk a little bit about how to get help with all of this because it is all pretty complicated. It can be difficult to manage, even if you have help. And so having a lawyer involved in the case, even if it's just as a consultation to understand how the process works or what the criteria are for a specific service, having a lawyer can be a huge help in being successful in an appeal. If you can't afford to hire your own attorney, there are a few organizations up on the screen, including Disability Rights New Jersey, our organization. All of us provide some level of no-cost legal assistance. Sometimes we provide full representation where an attorney can go with you to a hearing and handle the hearing on your behalf. The same is true of Community Health Law Project, and the same is true of legal services. I just want to emphasize that we don't take every case for full representation, that often we are just providing advice, counsel, and self-advocacy support to help people handle their own hearings. And that simply is a numbers game. There are more people who need help than we have staff to help them. And so we try to spread that out as far as we can to help as many people as we possibly can. And of course, Community Health Law Project and legal services make their own decisions on which cases they take or how many they would take at any given time. I would suggest that if you need legal help, if you find yourself in a position where you're looking at an eligibility problem where you need to appeal, or a service denial problem where you might need to appeal, it's best to reach out to an organization, one of us, right away, to understand who might have capacity to help you. Because of some of those tight deadlines, it might make sense to even request your own hearing first and then start calling around to see if you can find legal help in either the eligibility or the managed care service denial context. You can always withdraw a hearing request if you decide you don't want to go through with it before the hearing actually takes place. I promised I'd put our information up on the screen. Here it is. There's our physical address, our toll-free number, our out-of-state number, which is also on the screen, as well as our general inquiry our email address, which is advocate@disabilityrightsnj.org. You can also go to our website, which is disabilityrightsnj.org, to see more information about all the different things that we do, services we provide, how to get in touch with us, as well as our social media presence. All those handles are up here on the screen too. As I look down at the clock, it is 12:45. We timed it almost perfectly for 15 minutes worth of questions and answers. And since we covered so many topics, I assume there'll be lots of questions and answers. So I'm going to stop the screen share in just one moment and see if we can get some of those fielded.
Great. Thank you so much, Melissa and Michael. That was a really nice layout of how the system works because it is very confusing. So thank you for that. So we are going to now take the opportunity to answer some questions. So if you have any, please put them in the Q&A box and we will get to those. And the first question I have here is, can facilities or organizations choose to only accept MLTSS Medicaid and not regular ABP Medicaid? Any of you like to take that question?
So I'll field that one, Melissa, unless you had a specific answer ready to go. Okay. So yeah, provider agencies, I think, right, facilities and organizations, people who provide services in the Medicaid context, depending on what kind of service they provide in the managed care world, they might only take somebody who's eligible for MLTSS because they might categorize their service as one of those specifics that Melissa laid out, especially in the TBI context, that come with specific compensation rates, right? They may only get paid enough to provide that level of service if it's an MLTSS TBI service rather than, say, characterized as a medical visit or physical therapy under regular Medicaid. And so in that case, providers may limit who they see or which networks they participate in based on the kind of services they provide.
Great, thank you. The next question we have is, what happens if providing an accurate 5-year look back isn't really possible, maybe because they're newly disabled and they might not have all of the pieces to put together?
We've seen that here. It is a very difficult situation to try to figure out if you can't access somebody's records. Especially banking records are usually what becomes the culprit. People don't always even know where they banked 5 years ago. And so there's something to be said that if it can't put together the 5-year look back period, in the legal world, we call it the burden of proof. You have to prove, if you're an applicant, that you are eligible. And so it means you have to be able to come up with those things. Sometimes with the help of a lawyer, you can put the pieces together, go to old bankings, interview witnesses, find banks that the person used to work with and get those records. Sometimes you can't put the pieces together and you might not be able to prove eligibility. It's a very tricky thing to do. And Melissa, I saw you unmuted.
Yeah, I think there might be times too, just like you can maybe rebut this presumption that assets are transferred, you might be able to prove hardship. But again, in practice, it's very, very difficult to do this. So that's another situation, I think, or if there's a specific issue or specific problem, try calling one of those agencies to see what the advice would be.
Great, thank you. Next question we have, are there any resources available on the NJ Family Care or other sites on recovery of estate and age?
I think there is. And Melissa, when we were actually putting this together, I think you had come across a PDF that kind of put those things together in one place from the Division of Medical Assistance.
Yes, there are some documentation. I don't know, Rachel, I could send some your way and then you could disperse them maybe.
Yeah, we could do that.
And I want to be clear though that those are more, again, like what we're doing now, just general information. It's a starting point.
Great. Yeah, if you get those to me, we can definitely get that out. Next question, are spouses' finances considered when applying for MLTSS? And if so, do you know the yearly amount for this year?
Finances are interesting when it comes to MLTSS. In some circumstances, you can actually treat the applicant as a household of one, where you only look at their income. Specifics matter. There are some, especially when talking about a spouse, when income is shared among the household, that some of the spouse's income might be attributed to the applicant, even if it's not the applicant's income. Things like providing housing without any kind of cost, or transferring money sometimes even, right, could count as income going from one spouse to the other. But MLTSS does have the benefit that there's a pretty good protection for spousal income that allows people with middle-class incomes to become eligible, even if they might not be eligible for any of the other Medicaid programs.
Great, thank you. Next question, what are the differences between services from MLTSS and DDD?
So we can try to address that. So DDD is specific. It's the Division for Developmental Disabilities. So people who are getting services through DDD have to meet that type of eligibility requirement, right? They must have a developmental disability as defined in that section. And they have their own services that they provide too. So maybe when you're looking on paper, the actual services might be different, might not be different, but they have different eligibility requirements to access MLTSS than to access DDD. Michael, did you want to add something to that?
I was just going to add that that's one of the DDD programs are waivers programs also, and they are exclusive, but one can either be on MLTSS or one can be in DDD. There are some people who are eligible for both, but you can't be on both at the same time. You've really got to be on one or the other at any given time. And I think Melissa's point is just well reinforced that they are different sets of services, and some people might want MLTSS type services over DDD or vice versa. And really have to be careful about making sure you're on the right program for the services you want or need.
Great, thank you. This one's a little bit more of a specific question, so if you can answer it all. This person said their son had a TBI within 14 months and they've applied to Medicaid. How does the 5-year look back apply, if at all?
Yeah, I think we're going to hold back from giving any case-specific advice on that one. Generally, I think the 5-year look-back period is still going to be there for all applicants. It's going to be something that's considered, but I wouldn't say there's a specific answer for your son.
Okay, great, thank you. One person's asking how you might be able to access your file if you've been on Medicaid at some point. Do you have any suggestions?
So I guess if you're outside, I guess the question seems to kind of have an assumption like you're no longer on Medicaid now. Yeah, so for our purposes, I think we're talking about people who are applying, and if maybe you were on Medicaid before and you're applying again, maybe you've become eligible again for some reason, and you want to know what the Medicaid agency had on you from before, that should be information you can get before the hearing process in order to, maybe there's something there that's relevant to your current eligibility. In those contexts, it's a pretty nitty-gritty kind of question how to actually get it. If you're talking about eligibility, there's a discovery process where you can request documents from the other side. You would have to ask the other side, and that could be either the county or the state division of medical assistance and health services. You have to ask them, usually in writing, for a copy of everything. And usually it's a good idea to ask for something specific. So if you think, oh, I know that back then there were bank records that I would really like to be able to point to today to talk about my eligibility, you'd want to say, I want to see also not just my full file, but I really want to make sure that you include in my file those bank records that I think you have.
Another question, are MLTSS benefits only accessed via the MLTSS application, or is there some other route?
So my understanding is that you have to be eligible for MLTSS to get the MLTSS services. So that would be its own application and its own process.
From the MCO, does a client or can a client get the statement of claims?
I'm not sure I understand that question.
Yeah.
I don't want to take a stab at it other than to say that it's something we could maybe glossed over a little bit quickly in the managed care appeal world. If we're talking about the appeal of a denial, a termination, or a reduction, you also have the right to see your full case file in those contexts too. So if that's what this person's getting at, the answer is yes, you can get your full case file, past claims, past assessments, anything that might be relevant. And really, it doesn't even matter if it's relevant. If it's in the MCO's file, you're allowed to access it in the appeal process. Again, making a request in writing is usually the way to go about that. That can be a headache. You might have to jump through a lot of hoops to get what you're actually entitled to there.
Okay, great, thanks. Once on MLTSS, do you get reevaluated yearly?
Yes.
Question. I actually don't know the frequency of reevaluation.
Yeah,
Michael,
in normal times, and this is partially because the pandemic, things were on pause for almost 3 whole years. But before the pandemic, and now that we're on the other side of the public health emergency, the official public health emergency ended back in April. Annual redeterminations of eligibility are the norm, and that's what's expected. It's one of the actually federal requirements. The state needs to look at every beneficiary once a year and check, are you still eligible? And that includes for MLTSS, clinical, and financial.
Okay, great. And is there a yearly budget for how much services can be funded under the MLTSS waiver?
No.
That's great. So, okay. Next question. What are options for living/services under Medicaid if someone is ineligible for the MLTSS? I don't know if that's a clear enough question for you.
Can you repeat it one more time?
What are the options for living/services under Medicaid if they're ineligible for MLTSS? So they said like a skilled nursing facility, et cetera.
I think generally, right, and Michael, maybe did, there's a lot of different Medicaid eligibility groups, and there's a lot of different Medicaid eligibility doors. We say options. So there's Medicaid Plan A, there's MLTSS, there's the DDD waiver. So depending on someone's specific circumstances, there might be different ways into Medicaid. And a lot of these waiver programs, like we mentioned, are meant to keep people in the community rather than being unnecessarily institutionalized. So MLTSS comes with private duty nursing. The supports program of DDD comes with private duty nursing potentially. So there might be different options depending on the specific situation.
Okay, great. We have someone who said that their organization has contracts with all of the 5 MCOs in New Jersey. And they're asking, since they have those contracts, does that automatically make them eligible to provide MLTSS services if a patient is eligible? Or are there additional requirements that they have to follow?
So I would say that's probably outside of what we could cover in this, and even honestly outside of our expertise. I think that's more of a provider contracting with the MCO, right? That's a pretty specific kind of area, and that's not something we really handle at Disability Rights. We only handle the beneficiary side of things. So I would tell them, if it's an organization, you might want to consult with your own lawyer on that and see what your obligations or your options are.
Okay, great. A specific question about whether or not funds from GoFundMe are considered as part of income, or, the whole package of assessing finances.
I would think so, yes. Any income received in a month, they have sometimes rules about whether it's, I forgot the exact word, irregular income or uncommon income, but any income you're receiving could be open for evaluation. Yeah.
Okay, great. Our last question that we have here is, how can somebody go about helping them determine if they qualify for services? So, what kind of help they can receive on that front.
So I think there are the county agencies on aging. If you're talking about being eligible for MLTSS, there are these county agencies on aging that can help do some assessments for the initial application. Rachel, I could send you a link to that too.
That would be great.
Okay.
Yeah. All right, great. Well, I think that we have covered all of the questions. So thank you again, Michael and Melissa, for all of your expertise. That was such a great webinar, and we really appreciate you taking the time to do that today. So if anybody in the audience has any additional questions that were not answered, I'll put my email address in the chat, and you can feel free to reach out to me, and we'll get an answer to that question that was not answered today. And then also, we've put in the chat the link to our evaluation. So please fill that out. We appreciate your feedback. And if you are looking for a certificate of attendance, you need to fill that out in order to receive that. So thank you again for attending, and thank you for all your questions and comments. And we hope to see you at our next webinar. And thank you again, Michael and Melissa. And that concludes today's webinar.
Thank you.
Thanks, Rachel.